Welcome to the Tejaswi IP show. I am your host Pratik Raj, and today we are diving into one of the most mind blowing patents ever filed, and it belongs to the king of pop himself, Michael Jackson. Yes, you heard that right. MJ didn't just moonwalk into our hearts, he patented his way into defying gravity. Let's break this down. So, the question is Michael Jackson filed a patent for what exactly? The answer is absolutely on March 25, 1993. Michael Jackson, along with co-inventors Michael Bush and Dennis Tompkins, was granted U.S. patent number 5255452, titled "Method and Means for Creating Anti-Gravity Illusion." Okay, this patent covers the special shoe mechanism that allowed Michael Jackson to perform his famous 45-degree forward lean in the smooth criminal music video and the live performance. Okay. There is another question that how does this gravity illusion actually work? The answer is the patent describe specially designed shoe with a slot of recess in the heel. This slot engages with retractable peg that emerges from the stage floor at the precise moment during the performance. The peg locks into the shoe, providing the anchor point that allows the performer to lean forward at an impossible angle without falling. Okay, when the peg retracts back into the stage, the performer appears to defy gravity as they return to an upright position. Okay, so there is another question that, but is not this just a stage trick? So how can you patent such a magic trick? So this is very great question. The key here is that Jackson didn't patent the illusion itself. He patented the specific mechanical apparatus that creates the illusion. Okay, patent law protects new and useful invention, and this shoe and peg system was a novel mechanical solution to a performance problem. The patent covers the physical device, not the artistic performance. So there is another question that what makes this patentable versus other stage equipment? The answer is the patent had to meet three key criteria. The first one is novelty, other one is non-obviousness, and the third one is utility. The invention was novel because no one had previously designed this specific shoe peg engagement system. It was non-obvious because while a stage harness existed, this particular mechanical solution using heel slot and retractable pegs was an innovative approach, and it clearly had utility. It solved the problem of how to create a gravity defying lean safely and convincingly. Okay, so there is another question that did other performers try to copy this technique? The answer is here is where patent protection becomes interesting. Okay, while other performers could still lean forward or create similar illusions using different methods like harnesses or wires, they couldn't use Jackson's specific patented shoe and peg system without permission. This gave Jackson exclusive rights to this particular method of creating the anti-gravity effect until the patent expired. Okay, so there is another question that when did this patent expire, and can anyone use it now? The answer is US patent filed before 1995 had a 17-year term for the grant date from the grant date. Since this patent was granted in 1993, it expired in 2010. This means the specific technology described in Jackson's patent is now in public domain, and anyone can use, manufacture, or improve upon this shoe peg system without infringing the original patent. Okay, so there is one more interesting question. is that are there other example of entertainers patenting their performance methods? The answer is while not common, there are several examples. Magicians have patented illusions devices, circus performers have patented acrobatic apparatus, and even some musicians have patented instrument modifications. The key is always that they are patenting the physical device or mechanism, not the artistic performance itself. Okay, so I want to cover three more question, and the first most interesting question. The first one is, what does this teach us about the scope of patent protection? So the answer is, this case perfectly illustrates that patent protection extends far beyond traditional technology sectors. If you create a new mechanical solution to any problem, whether it's in entertainment, sports, art, or any other field, it could potentially be patentable. The invention doesn't have to be groundbreaking scientific research. It just need to be new, non-obvious, and useful. That's it. Okay, let's take another second last question, that is, could dance move themselves ever be patented? The answer is no. Dance moves and choreography cannot be patented because they are considered artistic expression, not mechanical invention. However, as Jackson's case shows, the apparatus or equipment that enables a specific dance move or performance techniques can absolutely be patented if they meet the patentability requirements. Okay, and let's move to the last and most interesting question. What's the business lesson here for modern creators and inventors? The answer is, the key takeaway is to think beyond obvious applications when considering IP protection. Jackson and his team recognized that their performance innovation was not just entertainment, it was a mechanical invention worth protecting. So, today's creators should ask themselves, are we using any unique tools, any methods or apparatus that could have value beyond our immediate use? Sometimes your competitive advantage is not just what you do, but how you do it. Okay, so this is Michael Jackson anti-gravity patent reminds us that innovation happens everywhere, even on the dance floor. So the next time you see someone doing something impossible, ask yourself, what's the technology making it possible? And more importantly, is that technology protected? So that's a wrap up on today's episode of the Tejasvi IP show. Until next time, keep innovating and keep protecting those innovations. And for reliable and expert intellectual property legal services, contact Tejasvi IP today. Our team of experienced attorneys is dedicated to helping individuals and businesses safeguard their intellectual property rights in digital age. Thank you. Have a good day.